Okay. Call this meeting to order. Review last month's minutes. I looked at them and have no problem. Anyone else?
Nope. I move to be approved as written.
Second. All in favor?
Do we have any idea when we left the room? That was one thing that we didn't,
I sent you back some.
2 hours?
Yeah.
Roughly 2 hours, right?
All members of the public get a chocolate if they would like. Already offered it around. Everyone else already has one.
No, I said no.
I've already been like snacking on this.
Okay, so
Thank you.
we're going to be open for public comments. I will also note that we're going to be going over some of the ideas to amend the code, the fact, and our procedures. But any members of the public want to comment at the outset? My anticipation is that we'll spend an hour or less in open session on these things like the code, the fact, and the procedures. And then we'll probably have to go into executive session for some things. So you'll also have a chance to comment at the end of the open session if you'd like, as well as during any of the agenda items. Business for the board will have been reappointed.
Oh, I forgot to bring that form in to sign.
That's through like 2029.
We'll see.
I think that our council is giving a talk at an upcoming meeting in New York City, right? Who can tell us about that?
That is true. The title of the program is Astride Two Worlds, the ethical challenges for municipal attorneys. And it's really, they specifically asked me for a program that would qualify for continuing legal education credits for the lawyers. So the orientation of the program is mainly for lawyers, discussing, comparing and contrasting certain provisions of Article 18 of the General Municipal Law, the statewide code of conduct for local municipalities, with the rules of professional conduct that govern the attorneys in the practice of law.
It'll have some overlap with our work in ethics in this little island.
It will, and I think as long as you've mentioned that, I would encourage you to think about organizing an ethics training program for the town officers and employees. I have a program that I could present. I do it in many other municipalities that would cover both Article 18 and the Town of Shelter Island Code of Ethics.
Great, Stephen, thank you. That'd be an awesome idea, I think. Now, who's going to go to Stephen's thing? Are you going to? Anyone else?
Maybe.
Okay, well.
Will it be recorded?
No, I don't think they are. It's like a conference kind of thing.
I see.
It sounds like it's aimed at lawyers, but it may be of interest. Great.
And just, I did notice in one of the documents that you sent through, Stephen, at some point, you did talk about training staff.
Yes.
And I realized at that point we hadn't trained. It was one of the things I wrote a little note next to. We haven't done that. We just sent it out and made people sign things. We haven't done any in-person training. So yes.
Right. We talked about it, we just never really organized it.
Well,
So great.
We're new still. Newish.
Okay.
You can wake me up in the middle of the night and stand me behind a podium, and I can do an hour and a half.
Excellent.
In your pajamas.
Right.
Good to know. Now, we've ethics code update, which we're empowered to recommend to the town board when we think it warrants, and we have thought it warrants. We've looked at this at least once before. It was printed out on colored paper for everybody. But if you didn't bring that with you,
I
you'll
do.
have to look on a computer
Okay, I have that.
in terms of the ethics code. I had Christina printed on colored paper, so it'd be
Sure, I
easily.
have it in my file at home. I'm sorry, I should have brought it.
That's okay, got it. We've recommended several things in our first review. We're going to talk about some more today. Then my question procedurally is, we would recommend this to the town board. Then do they get to hold a public hearing and we don't have to? Or do we have to hold a public hearing?
No, that would be the town board. That would be the town board.
They can hold the public hearing.
You are making recommendations. Recommendations don't require a public hearing.
Good. Okay. 'Cause we had a hearing when we first adopted this ethics code, and I think that, that Bill was there, made some good comments.
I have some more that, from that even, that are, I'd say a second time.
Oh, good, thank you, okay. I just want to review in brief what we've already discussed, and then let's take another look at it. I don't think that we'll be taking final action today. I'd be surprised because Stephen will have to do some drafting for us and has some ideas that haven't been specified. Yeah.
Right.
But
Can I just, would I find this in an email or on the Board of Ethics website?
Board of Ethics website,
Okay,
it's the current code.
okay, thanks, sorry.
So I'll just say,
Deborah, it's in the latest email from,
well, I
No,
go to the Board of Ethics
The code.
front
oh,
page.
for the actual.
Just the ethics code, it's not the procedures, it's.
Oh, not the procedure.
Is everyone just taking a look at it? So we can,
Looking at the code.
yeah, the code,
Okay.
follow along a little bit. And we don't have to get everything done on every one of these, but to provide an overview. 8-4, a prohibition on the use of town position for personal or private gain.
Mm-hmm.
Mark Davies had thought this is a little too loose. What if it's your landlord you owe $100,000 to, and then you do a favor for him or her? Because this covers relatives and yourself and private organization.
How would that be, using their town position or official powers to secure a financial benefit?
This doesn't cover your landlord, your best friend, your neighbor. It just covers you, your
Not
relative.
using your town position to pay your rent. That's what I'm confused about.
Secure.
No, it would be to confer an official benefit. I'll give you an example. The town snowplow operator
Yes.
is assigned to plow his mother's neighborhood, the streets, the town streets in his mother's neighborhood. He thinks it would be a good idea to just take a few minutes and plow her driveway.
Mm-hmm.
That is a very nice thing for him to do, but that would be an ethics violation because he is using his town position to confer a benefit on his mother that isn't available to others. He's also using the town snowplow and compensated town time.
Right. So this is an area that we've struggled with, whether to include like your landlord, your best friend, your neighbor, under the interpretation of this. And what we've done is just use common law, general language as applied to town employees. And Stephen, do you agree? But this is what's covered in state law. What we have in section 8.4 is the minimum covered in state law, I think. Yeah. Stephen, Mark Davies had thought this had a loophole. Do you?
Here's the way I draft this provision in codes that I myself draft. I state that no town officer or employee shall use his or her town position or official powers and duties to secure a material benefit, whether financial or otherwise, for, and then I have A through E. And A through E are himself or herself, a relative or member of his or her household, any private organization in which he or she has an interest, a client or customer from which the officer or employee knows that he or she, his or her outside employer, firm, limited liability company, partnership, or association or corporation in which he or she is the owner of more than 5% of the outstanding corporate stock, directly or indirectly derived income in excess of $5,000 during the previous 24 months, or E, a person from whom the officer or employee has received a private loan or loans or a gift or gifts having an aggregate value of $75 or more during the previous 12 months.
Okay,
So we tried to define these, in the
Yeah, we have
definitions,
definitions of,
in the definition section of our code, we tried to
Right.
do what you're saying. So this
Right,
would be,
but
this would kind of repeat that.
well, look, you are the Board of Ethics. I am not, and I want to express my opinion, mindful of the fact that it's merely my opinion. I think this code has way too many definitions in it. Many of them are useless. Many of them are misleading traps for the unwary, which I'll point out an example. And to the greatest extent possible, when a term needs to be defined, it should be defined in context, because the average reader of a local law like this doesn't necessarily know that every time they read a provision, they must refer back to the definition section to see whether there is a defined term that has a meaning other than its plain language meaning. And I'll give you the most egregious example, I think, is, and look, I should say, I think this board is an excellent board and does phenomenal work. I don't want you to think that any of my comments diminish that in any way.
that's fine.
But
So what's in,
the term relative should not include unrelated household members. That is contrary to the meaning of those words as used in the English language. And somebody reading the text of the law that doesn't refer back to the definition section would not understand that a member of the household is defined to be a relative. So instead, in the text, when you speak about relatives, you should speak about relatives or members of the household.
yeah, I think that's a good point right there. But I also think that we have few definitions and they're clear, and we don't want to repeat, we don't want to define relative or officer and employee
Every time it comes up.
up.
Yeah.
No, relative should be defined.
Yeah.
Officer and employee, I don't think needs to be defined. Town needs to be. Is it possible? Is it conceivable that anyone could read the word town in the code of ethics of the town of Shelter Island without knowing that the word town refers to the town of Shelter Island? It's inconceivable.
don't define town.
Okay.
Oh, there it is, town.
And there may be a little more cleaning up in there. And we appreciate your expertise, and let's,
Can I I'm still confused about what 8.4, what the problem is with 8.4. But in 8.12, we talk about something that would go right to the example used about the use of town resources. No officer or employees may use or permit the use of town resources for personal or private purposes, include but are not limited to town personnel, married vehicles, blah, 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 blah.
so would that
That would cover
cover
the snow plowing example.
Well, it covers that example.
and the
Yeah.
hypothetical where you do something in favor of your
For your
landlord?
favor, yeah, or in favor for your landlord, that's why I'm so
Yeah,
confused
that
about the
you owe
landlord.
$10,000 to,
Oh,
or your best friend,
Well, but
providing the financial benefit.
to them.
Yeah, no, to the employee. You're using a town resource to
Yeah,
defray an obligation.
What I liked about his rewritten 8.4 was he added financial or, I can't remember the or, but you
or other
material,
material.
thank you. I think
Yeah.
we should definitely add that.
Well, we
No?
went around the block on that about 5 times because the state law defines it as material benefit. What's material benefit? Who knows? We defined it clearly as a financial benefit.
And we've defined
Direct or
financial
indirect.
benefit of anything of value, whether in the form of money, property, services, loan, travel, entertainment, hospitality, or promise, or any other form.
Anyway, let's come back on that. That's a good thing to come back on. Okay, but that's the reasoning why we defined financial benefit is because people don't know what material benefit is. We say it's a direct or indirect financial benefit, and we lay out examples of it.
Yeah, I was the one that really objected to the use of the word material
Yeah.
benefit, because material has it's a quantitative, to me, a quantitative essence. Is it, more than a minor benefit, more than a 10,000 benefit?
Yeah,
And we didn't go that way.
right.
Okay.
Yeah, but now we have Stephen on board. And Stephen, what do you think about material benefit? It
Is
doesn't
that in
say
what,
that-
in the language that he used? That's why, no.
Yeah, he said financial or material
No, he
benefit.
said material.
Well,
Financial or material.
one of the things I think is very important is that the local code incorporate all of the rules that are set forth in Article 18 of the General Municipal Law. Otherwise, you're setting up a situation in which someone might read the town's code of ethics without knowing that there also is a code of conduct in the state law that they must comply with. And so if Article 18 uses the phrase material benefit and you don't include it in the town code, then you may be misleading a town officer or employee into thinking that it's okay to confer or accept a material benefit as long as it's not a financial benefit.
What is a material benefit?
Well, the fact of the matter is there could be an infinite number of different factual scenarios that could arise.
Give me an example of
The
a material benefit, so you mean a non-cash benefit or a benefit
Yeah.
for property?
How about preferential treatment?
Okay. Now what's material about that? That's what I'm confused about. Are you using it in the quantitative sense?
Well, the material, well, not exactly quantitative. Quantitative suggests some kind of mathematical quality, but it may be material just because it's significant. It's, you don't want, you have to draft in a way that kind of serves two masters. On the one hand, you want clarity so that people understand what the rules are. At the same time, you want sufficient flexibility so that the code will enable you to apply it to situations that will arise that you can't predict as you sit here today. Because the possibilities are infinite, and the devil is always in the details. So that's why it's difficult to draft too specifically, or drafting too specifically could leave you without the tools that you need in the future to achieve the purposes of the code.
Stephen, did you say you would change financial just to material, or would you make it material and financial?
Financial or material. Financial or other material benefit.
But you're using it more like significant as synonymous with significant?
No,
Yes.
I thought you were using it more, I'm sorry, more like just something that's not financial, but like having your mother's driveway plowed. That's a material benefit, but unless she had to pay someone else to plow it, it's not a financial benefit.
Well, that
Right.
You're nodding yes, is that an okay way to use material?
I think, I agree with your statement, yeah.
Okay, well, I think we're of like mind on that. All this, just need to work out the details because the definition here for financial is anything of value, and then it goes on and defines it further. But it's fine with me if it says financial or material and then defines material.
I do. That's the hard part.
So that's one thing, Stephen, if you could, at some point on your to-do list, provide us with your suggestion for
8.4.
the first one that you mentioned, or that I mentioned, 8.4.
8.4, you have a list of,
And a redefinition or addition to a financial benefit. All right?
Now going to
Just
something else that he was saying, I don't know that we're going to include everything that's in Article 18 in this code.
Although we tried to.
Well, no, we really didn't. I mean, we backed off on a lot of things.
No,
You know,
this-
if you take a look at the codes that I wrote for the town of Southampton, the town of Huntington, the village of Port Jefferson, and other municipalities, they're not significantly longer or more complex than your code, and yet they incorporate all of the provisions of Article 18 in simpler language, not in the language used by the state law.
Okay, I do want to say that we have everything from Article 18 in here. We just didn't include that one subsection that we have to work around. But it's fine with me to reevaluate the Southampton code. We actually started, like I mentioned, with your annotated version of the Southampton code a long time ago.
Before it was-
And, it's fine with me.
Yeah.
Yeah, it's fine with me to reevaluate this. I just want to give a little sense of the board on some of this stuff right now. I'm going to move on to another topic in the code. And if you guys want to interrupt, raise your hand and we'll give
Just
you
Curious to have.
90 seconds.
One thing on that, I mean, back in 2022, when I contacted the board and was complaining about our, at that point, different code of ethics, one of the things I did was I said, would be the suggestion, would be the review and consideration of other town codes of ethics. There are many to consider, but I found the town of Huntington, which I did not know that Stephen had done, to be particularly helpful and on point. I think he was very correct in pointing out that code and utilizing how you can incorporate from 18 into other things. So I would go along with that, and I totally agree with him on using the word material. I mean, because it gives you, as he said, flexibility in places where there could be a novel issue that comes forth. You can't define everything in advance.
Yeah, we did try to include the material concept under the definition of financial benefit where it says anything of value.
Yeah, but
It's not the same.
it's not the same.
Gotcha.
I like adding it, it's only one word.
Yeah, but I'm no problem. Stephen, what do you think's a better model, Huntington or Southampton?
Well, insofar as this provision is concerned, they're probably identical. I have a standard code that I draft. Of course, every local municipality tinkers with it a little bit, but they're substantially the same.
But if we were to look at one as a starting point, would you start with Southampton or?
Start with
The reason I like Southampton is we have your annotated version.
Southampton was more recently drafted, so you
It was super
won't go
long.
wrong.
Yes,
Super
yeah.
long.
It was long comments.
Had a lot of stuff in it.
Yeah, it was so long, Southampton.
Yeah.
It might be.
Maybe we should, can we look at your template?
Yes, and Southampton, first of all, the annotated version that I gave you was very long because it included annotations. Also, one of the things that makes Southampton's code longer is that there's a financial disclosure section, which the town of Shelter Island doesn't have and is not required to have because its population is less than 50,000.
Right.
So, yeah, I mean, I'd be happy to provide you with a template. I would eliminate the financial disclosure requirement
Yeah.
and provide you with a template.
Okay.
Probably the
We'll
easiest.
look at that again.
Yeah.
Just to move on to kind of get a sense of the board on some issues in here. The next one that we had was 8.5 disclosure of interest in legislation, where we have previously said it does not work here to ask every disclosure to be put in writing in a forum for the Board of Ethics. We want disclosures to be, if it's an advisory group, in the minutes, if it's an employee, given to their supervisor or their hiring authority. It's just, we've had this in here to have forms with disclosures, doesn't work.
I completely agree with you.
I'm just getting a sense of the board, and we'll come back on these later. The other one, under 8.9, private employment and conflict. We need to fix this to include the provisions of 805A1C, which I think is the only, to my knowledge, the only part of the state code that we didn't cover fully. And it's come up recently in discussions with Mark Levy and with you and with the comptroller's office. And
That was one of the things I was going to say today is 805.1C. It's,
Yeah.
and it had, how it related to a situation that I think should never have occurred in the town relating to the planning board. So
yeah,
that is,
yeah.
that
We're aware of that, and I'm not sure what's a matter of record concerning the planning board, but we're very aware of that and the interest to get it back into here.
Right.
Can I ask a
Yeah.
question about that section, please? That was 8-9 that you were referring to?
Yeah,
Am I right? So I may have misread this because I read it quickly preparing for the meeting. But it seemed to me that the last portion of 8-9B and the entirety of C are redundant. Am I wrong about that?
yeah, it conflates two sections in state law.
There was a drafting problem here. Remember I sent you, said it was like we dropped a half a sentence somewhere and it didn't make sense. And so, yes, that has to be corrected.
Yeah, we can correct that. B, 8.9B, at the end of it says, where compensation is to be dependent upon any such action. Well, that's one of the subsections in state law, but not the other one.
Yeah, no, it just, it was a drafting error.
It's a drafting problem that we want to fix this time.
Sure.
It could have real life application, as we've seen. 8.10, future employment. We took this from the comptroller's model code. B has a 1-year cooling off period. The comptroller actually had a 2-year cooling off period. We went with 1. Otherwise, it totally matches the comptroller's model code. Now, Stephen, I think that you had thought parts of this is too draconian.
Yes, I do. I agree with 1 year rather than 2, by the way. But B should not prevent you from having employment. It should prevent you from appearing on behalf of your new employer before your former board, department, or agency. That's the cooling off period. It already says that you can't pursue or accept employment while a matter is pending or 30 days thereafter.
Right.
So what this B really should be the revolving door provision, so that you're a member of the, you're working in the building department on Monday, you retire on Tuesday, and on Wednesday, you're back before the building department representing your new employer. That's what we don't want. And not because we think there's anything nefarious going on, but we don't want to give the public the impression that you will have an advantage in dealing with your former colleagues over a member of the public. We want there not only to be a level playing field, we want there also to appear to be a level playing field. So that's the revolving door provision. And I do not think that we should prohibit something that that the state law prohibits for former officers and employees of the state. They are prohibited from even sitting in their new employer's office and advising their new colleagues about the best way to approach the town, or how to fill out the application, or providing other back office services. I don't think that providing back office services has the effect of undermining public confidence by giving the impression that one applicant will have an advantage over the other. I think the knowledge and experience that a former employee has gained while employed by the town belongs to them, and they should be free to market it after they leave, provided that they're not doing that in a way that undermines public confidence.
So,
How does-
But it's a question of whether they're representing them in connection with a matter that was before the board while they
Well-
were the member.
If it's a matter that they were personally and substantially involved with, then yeah, I would say they should not do that. But that's the particular matter ban. The particular matter ban is permanent. The particular matter ban says that at no time
under
after you
C,
leave
right.
town government, may you provide compensated services to a private sector employer in connection with a particular matter that you participated in a substantial, personally and substantially, while you're employed by the town.
This is going to sound like a ludicrous example, but let's just say you know that somebody sitting on the board that has to approve your plans for a new house loves the color pink, because you were there when they talked about pink at every meeting. And you say to them, just present a house that's painted pink and they'll approve it. But you don't show up at the meeting because you're not allowed to. But the person who does show up knows that it has to say pink. Isn't that a misuse of your inner knowledge that these people love pink? I know
No,
it's a
there's
silly
nothing-
example, but
No, that's a good example. There is a prohibition against making personal or unauthorized use of confidential town information, even after you leave town employment. But I don't think you could reasonably describe a board member's preference for pink as being at all confidential. In fact, anyone who would be an observer of the work of the board, and board meetings are broadcast, might recognize over time that that board member has a preference for pink and will vote in favor of a pink proposal.
Right.
So I don't think that is a problem. Your knowledge and experience belongs to you, and it's fair game, in my opinion.
Stephen, can I ask you what your problem is with section B? How would you change the wording that we have in section B?
I don't think that you should prohibit rendering services. I think let me turn, I happen to have the Town of Huntington Code here. And I'll read you what, here's what the one-year provision says in the Huntington Code. No town officer or employee for the one-year period after serving as a town officer or employee shall appear before or communicate in any form with the town office, board, department, or comparable organizational unit for which he or she served, except on behalf of the state or a political subdivision or instrumentality thereof, or in furtherance of the interests of the town with the approval of the Board of Ethics upon application of his or her former town department, agency, board, or commission. Now, of course, I would not interpret that to prohibit social contact.
Yeah.
But it's the communication, it's the appearance. You don't want during that one-year period, the former employee to be the face of the application, the one who walks it in, the voice on the other end of the telephone, the author of the email or letter. Because that gives the impression that they will be in a position to get favorable treatment from their former colleagues.
Right, instead of, for instance, let's say an architect leaves a board and quietly advises or consults with a consultant who goes and then appears in front of that board.
Right.
That would be prohibited under this, I believe, because they can't,
yes.
but not
Not
under
under
what
his.
Stephen's saying. As long as a third party,
Is the one who shows up.
right, kind of like a beard.
exactly.
Yes.
I'm not exactly comfortable with
So
this. Yeah.
it's to be discussed more, Stephen, but we would love to know how that be drafted and then
Sure.
let's discuss that. Is that okay?
Yeah.
Mhm.
Okay with everybody?
Yes.
Okay, thanks, Stephen. I mean, it's great to have your expertise. 816 gifts.
But before, Bill, do you have a comment on that
Yeah.
item?
I'm thrilled you have him.
Yeah,
He's great.
Yeah, he's great.
for sure. If anyone has any comments, we'll give you 30 seconds. Just kidding. Gifts. Stephen, you thought the 816 gifts should be clarified?
That
I guess-
that is the absolute terrible drafting that you find in Article 18. It's direct, that parrots Article 18 on gifts. It, years ago, it was declared by one trial level court to be unconstitutionally vague. Now, no appellate court has ever done that, so that case is kind of an outlier. But the point is that this provision doesn't give sufficient guidance to officers or employees of the town as to what gifts are prohibited. And it doesn't give sufficient guidance to you about how to enforce the standard. It says essentially that you can't accept a gift of any amount or solicit a gift having value in excess of $75 under circumstances where it would appear that the gift was intended to influence or reward an official act. So you have to somehow divine what it would appear to one person was intended by another. It doesn't give a clear standard to adhere to.
As you noted, did parrot Article 18. Is there a better definition in the Southampton Code?
Yeah, here
His
here
template
is,
code, let's focus on
yeah,
that.
It does, yeah,
No, I'm talking about, let's focus on his template code that he's going to send to us.
exactly.
Yeah.
There's a
Not
better
necessarily.
definition in your template code?
so what I do in the template code is I also reiterate the Article 18 standard because, like it or not, that applies in the town of Shelter Island because the state law says so. But then I add, no town officer or employee shall accept any gift, tip, or other benefit from a person who the town officer or employee knows or has reason to know has received or sought a financial benefit from the town within the previous 24 months. And further, if you're going to solicit the gift, if you're asking for the gift, you have an affirmative duty to investigate and determine whether they've received a financial benefit from the town during that period of time.
Okay, so that's clear, and that's something that we would like to compare side by side at our next meeting. Is that okay with everybody?
Yeah.
Thanks, Stephen. Let's go on to Article 2, Administration, Board of Ethics, 818D, as in Duff 2. The last line on that says probable cause. We want to change that to reasonable cause. We don't use the criminal standard of probable cause. I think we talked about that last time.
I'm sorry, you said
Yeah, I
reasonable
wouldn't-
cause?
So
No, I
no
would say
probable.
reason to believe. Let me just find it again where it
Okay.
appears.
818D2, last line.
818B2. Yeah, if it believes there is.
No, reasonable cause,
Yeah,
it must
think
be.
of a reason. I mean, our interest in all this
See, the-
is to make
the
it
reason-
clear.
I'm sorry, the reason I'm hesitating is just like probable cause is a term of art in the criminal law, so is reasonable cause. So I might use a phrase like reason to believe.
You believe. Yeah. Seems reasonable.
Or a significant likelihood that there's a violation, something like that.
Reason to believe, easier than significant.
Okay.
Then 819 investigations. A. We talked about this last time too. we want to be able to accept anonymous complaints. And we can revise that in such a manner that it doesn't seem to exclude them. I've got some possible language on that. I'm sure Stephen can help with the drafting too, for reasons.
Yes, and also, I hope you saw it, I sent suggested forms for both filing an ethics complaint and requesting ethics advice.
Yeah,
Right.
so we talked about
None
this.
of those are anonymous. None of his suggested forms
No,
are
those aren't
anonymous.
anonymous,
Yeah.
but we talked about having forms on the website may help to prompt people to inform themselves on how to do it. They can also just email us. They don't have to fill out a form. No problem with
Right.
having a form,
Right, right.
in my view.
So if someone can submit a complaint without identifying themselves at all,
Yeah, anonymous.
and we can't go back to them to ask for clarification or anything?
Right. Nor do they have the right to get our opinion on that. If you submit a complaint identifying yourself, we have your contact information so we can get more information. And
Right?
plus, you have a right to get the outcome. If they just do it anonymous, you don't have the right to get the outcome. But that's a negative for anonymous.
We talked about the fact that we can, on our own initiative, investigate something.
No, I know
So
that.
it
That
wouldn't
could
be any
just,
different than,
okay.
It's just not to say if you send us something, you have to identify yourself. I mean, I would rather they do, obviously, by far, but
But Shelter Island is a small community, and I
Yeah.
guarantee you that there will be people who will be afraid to identify themselves. And if you require them to do that, you will chill ethics complaints.
I think we understand that and we'll do final review of that later. You know, 822 posting and distribution, we want to fix up a little bit because maybe. But that's the stuff that we've covered in the past. Anyone want to add anything to this preliminary re-review? Anyone in the audience? Bill?
On this, I have later.
Okay, so I guess what we'll want to do is to look at Stephen's template or the Southampton version annotated
Can
again,
I just mention one other thing while we're at it?
please.
52 pages.
I mean, I'll have other comments, but in 8-18, D1, it provides that officers and employees may request ethics advice concerning themselves. That's true, and that's a good limitation, but I would add one other, and that is, or a town employee that they supervise. So that a supervisor who spots something can ask the Board of Ethics for advice with respect to their subordinate, so that they know what action to take as a supervisor.
And would that be a confidential ask?
Ethics advice should be confidential, yes.
See, the way we have confidential, we don't share with the town board, the outcome. All other types, we do share the outcome with the town board because we advise them and
Right.
they should know. So I'm not sure where that supervisor asking about an employee would fit in that scheme.
we did have something like that. I mean, supervisor told an employee to go get ethics advice.
Yeah, in which case the employee gets confidential.
Right, we had a situation similar.
How do you
Well-
think?
Then they don't.
Well, I think the confidentiality applies unless you find that there has been a violation of the ethics code. In which case, the matter crosses over from advice to a complaint or an investigation.
I think we think of advice as being ex ante, in advance of any activity. Rather than turning into a complaint about somebody where they say something has happened.
In the case I'm thinking of that we advised the employee to rectify the situation. He did, and therefore it remained anonymous.
Right, it's confidential.
Yeah, it stayed confidential.
He or she asked for
Asked for a-
confidential. It was confidential, they can be assured we'll always keep it that way.
Right.
But if someone reveals if someone in the guise of a request for advice reveals to you that there has been some serious violation, that under normal circumstances, you would feel justified in investigation by the board. The mind can conceive of such a situation. You don't want someone to be able to immunize themselves by,
No, I
by
understand.
requesting. Yeah,
We would give an opinion, stop doing that. And then if they don't, we can initiate an investigation on our own that then goes to the board,
sure.
town board. That's kind of how we've envisioned that. If somebody,
What if the employer asks, and we say to the employer, yeah, you're right, this isn't kosher? Then what? What if it comes from the employer, which is what
yeah,
he's
that's the
suggesting?
point. I don't know. You're suggesting that could be confidential or
The boss.
not, even though it's not relating to the boss, but to the employee.
Yeah.
That's a
Well,
gray area.
The supervisor may not want his or her subordinate to know that they've gone to the Board of Ethics.
Okay.
But you can also advise the supervisor in your confidential response that if this conduct continues, you would regard it as a basis for the Board of Ethics to take further action.
Yeah, it's an interesting thought that we should pursue, I think. What we've done is, we've had like informal guidance that I think I shared with the town board for, let's say, the assessor's office on what kind of terms they might apply to hiring,
Right.
not an active real estate
Right.
license on the island. And that's been in that kind of gray area too. Right?
Oh, that seems clearer.
Mhm.
That seems clearer, clearer,
Okay,
your example.
well, I think
It grew out of an anonymous. It grew out of an anonymous.
it did, yeah.
Yeah.
I'd be happy to pursue what Stephen's talking about there. Is that-
You can add some language to certain, allow somebody to report or to ask about the conduct of somebody that they supervise.
I think it's a good idea.
Yeah, okay, and you said that
You
that,
know, I'm sorry, there's one other thing that just caught my eye. 8-21E,
yeah,
misdemeanor. Any town officer or employee who intentionally violates any provision of 8-13 will be guilty of a Class A misdemeanor and, upon conviction thereof, shall forfeit his or her town office or employment, subject to any applicable provisions of law and collective bargaining. You, to the extent possible, you want to stay away from designating crimes. Because if you suspect that someone has committed a crime, my advice to you would be do nothing. Do not take any action. Refer it to the DA's office, because if you take action, you may, on the one hand, somehow undermine the prosecutor's case by notifying witnesses, spoliation of evidence, and so forth. Or on the other hand, deprive the subject of the investigation of their first Fifth Amendment privilege, or to state it differently, making them choose between defending themselves in an ethics investigation on the one hand, or asserting their Fifth Amendment privilege on the other. So if you believe that there may be criminality involved, I would refer it and do nothing until the DA's office has determined whether it will or will not prosecute.
So we should just pull E out entirely because the next one says that we can refer any information.
Right.
Yeah.
Also-
I agree, this is
also-
not something
Yes,
that we drafted.
state law, an officer of the municipality, an officer or of a municipality, their position becomes vacant if they're convicted of a felony. Not a misdemeanor. Other than that, only a Supreme Court judge has the authority to remove a municipal officer. A municipal officer cannot be fired.
Okay. Finally, something we can blame on Stephen. Because he drafted this whole penalty section. And if that's a better way of handling it, that's fine. It does refer only to 813, which is the interest in contracts, not to the whole thing.
Oh, it does?
Interest in contracts is a special section
Oh, right.
of the state ethics law.
Right, and as you know, Article 18 makes certain violations of that provision a misdemeanor. It
Yeah,
has to be knowing and willful, among
Right.
other things. So I would not stomp around in the criminal laws petunia garden.
great. Well, thanks, and I'm gonna summarize some of the things we talked about in the board report and assign people, especially you, Stephen, to draft some language for our next meeting.
Sure.
Anything more right now on that? Bob has to leave at 5:15, so.
I could stay on Zoom. I could stay on Zoom if that's it.
Okay.
Oh.
All right, can we move on? Thank you, Stephen. It's great. Anything from the public on these for now?
Are you talking about procedures yet?
No,
Okay.
but that's next. Let's talk about procedures a little bit. We did we adopt them in May, Christine?
Well, it was in the form of a draft in, well, what I have on my computer is of January 25. I thought, maybe I'm thinking of something else.
I think that we agreed in
Okay.
concept. You put it in a form that's readable.
But it was intentionally partial when I did that, because I really didn't know what else should be in here.
Yeah.
And I kind of said, tell me what else you want to do, and I'll help try to draft it, but
Okay,
I didn't
okay.
I didn't intend this to be the end of it. I don't know what other procedures we want to have included here, but I didn't want to make some up.
Good. And we went over them a few times before
Yeah.
this too. So
Can
let's
I-
just, please.
Thank you. Just one or two quick comments. First, you must have procedures for conducting investigations. That's very important. People are entitled to due process, and you must have established procedures before the investigation commences. But in areas other than investigations, I would be careful about too many stated procedures, because a failure to follow your own procedure could be a basis for someone challenging an action of the board. So you don't want to adopt procedures where procedures aren't necessary or required. And certainly in the area of giving ethics advice, you don't need a whole bunch of written procedures, formal written procedures. You want it to be, to the extent possible, a relatively informal process.
Right.
And second comment I have is under B, third-party complaints, D. One of the requirements set forth here is that the complainant state the specific code sections alleged to be violated. Well, members of the workforce and members of the public are not lawyers for the most part. And many of them are not college graduates. And I don't say that to disparage anybody, but I don't think you can expect people to have the kind of familiarity and facility with the code of ethics that you have developed through your experience in serving on this board. For the most part, people don't know what an ethics violation is. They see something that strikes them as wrong and they file a complaint. I don't think you should put the burden on them of identifying a code provision. Now, the ethics complaint form that I provided is designed to assist them in organizing their thoughts and understanding what an ethics violation is, and it lists categories of ethics violations and asks them to check them off, and has an area in which they can indicate other and describe it. So I would delete this requirement.
Okay,
One of the forms I was looking at, and I don't remember whether it was yours or somebody else's, though, did have two things where first it was a fill in the which code it violates, and then below it was describe what happened here, or what it is in, kind of free language. Was that your form, or I looked at so many forms recently?
No.
Or was that one of our forms?
The form that I
We have a
provided,
form.
Do you know the one doesn't have that? Because I had the same response you're having, is like,
Right.
I don't know what number it is, I just know that's wrong.
Right. Right. So the one that I provided to you has categories.
I saw that
Not
checklist, yeah,
identified, yeah, and check them off,
yeah.
and a space for other.
yeah.
But it's not
We
key.
asked, could we ask them to specify the financial benefit?
Or material.
We're asking to provide as much detail as possible. Then we get back to them. We don't want to be too bureaucratic with forms here.
Yeah.
Although I think the form is good to inform somebody that wants to look at a form and really educate themselves.
Right.
That's my feeling. But
Every contact that you have with a member of the workforce or a member of the public should be viewed as a teaching opportunity.
absolutely. Oh, did you have some comment on our draft procedures?
Actually, something that I don't see anywhere that I think, and I know I've mentioned some of this previously, that I think would be helpful. And remember, I'm coming from a corporate world doing this, not from a municipal world doing this, which is disclosure to me is one of the most important things, and it protects everybody. It protects the person who's doing the disclosure. It protects the people receiving the disclosure, so that at the end of the day, you can basically separate things that actually have meaning and things that are de minimis. And one of the things that I would highly recommend is to have a periodic conflict of interest questionnaire, not, something that is huge, but that is, simple and to the point, that goes out to the employees, that they fill in, so that you have basically a warehouse of where potential conflict exists, that they're disclosed, and then you can act from there to see, well, in this type of situation, it's meaningless to what they perform, but in others, there are situations where they have to recuse themselves, and there could be some, as I've said, that it's so broad and has so much undue influence that it just can't exist at all. But without that process, I think you're just reaching at times for putting out fires or getting things from a complaint, and you could have a basis. And one of the other things is at the end of filling out the conflict of interest, I know right now everybody has to, basically sign a generalized form, but that they affirmatively state that it's true and correct, that they have read it, that they understand it, they are in compliance with the conflict of interest standards and the standard of conduct that's in their employee manual, and that if there are changes, this is very important, in circumstances, that they will immediately update their response to the town. This just gives protection to everybody. It protects the people that are filling it out, not just the people that are receiving it.
Yeah.
So I had a full compliance department report to me, so it's easy for me to say that. But if you keep it short, it's not something that becomes a burden, and you come up with some type of, every 2 years, every year, whatever, because people do forget that they're supposed to immediately update it. And it's upon hiring and upon some type of periodic review.
I think we would do it after we do the education, so that people
Oh, yeah.
actually understand what it is that might potentially be a
Yes,
conflict.
the training thing I thought was spectacular.
We're asking them to self-disclose any conflicts of interest that they have?
Well,
themselves.
I wouldn't frame it that way. The way it's done in larger municipalities is through a requirement of annual financial disclosure. Now, annual financial disclosure is a requirement that everybody hates. They regard it as an invasion of their privacy. But we can develop an abbreviated disclosure form that doesn't frame these questions in an accusatory manner,
Right.
but just requires disclosure, and that sharpens in the minds of the individual where their conflicts might lie.
Let me just say, we have considered this. There are systems that are annual or preemptive disclosure systems. It's required in this state for cities of 50,000 or more. Smaller cities, it's not required. The system that we adopted is what would be known as situational disclosure when they arise. We have thought, and I have thought, that disclosure forms are problematic in a town this small. And I come from a background where I used disclosure forms many, many times as a reporter to learn things and to ding people. And my father was the chairman of the State Public Disclosure Commission. And there's a shocking lack of disclosure of even things like campaign contributions, in this state. But it's people hate those disclosure forms. And let me just one more thought. If they disclose on themselves, does that mean that they should also disclose on their first degree relatives that we've defined?
No, because if you do a questionnaire, you're basically asking only to their knowledge, if any of their first degree relatives are involved in however you're going to define it. So you don't have to do a broad brush here is what I'm trying to say. You can come up with something that is relatively user-friendly. Not the fact that you have to do it is not user-friendly, but.
I feel like we're talking about two different things. A financial disclosure form, which if you gave it to me as a member of a voluntary board, I'd say, fine, I'm not going to tell you anything, I'm off the board.
Right.
Or a conflict of interest disclosure form, where if you ask me, are you aware of any conflicts of interest between your conduct, your position as a member of the ethics board, whatever.
Do you have
More specific,
do you
because
have contractual relation, et cetera, things like that?
again, most of our
Does your-
boards are voluntary, right? So that's asking a lot of
I'm
people.
on,
Yeah,
community housing, I
Yeah.
know that, I fill it out, so. And just because something exists does not make it a conflict of interest. And that conflict of interest can be cured or accepted, and it's easy to do that by disclosure. I mean, I'd have our board of directors do that all the time on things that were totally de minimis. It would be one little bit, and it was a housekeeping thing. I'm just saying I think it helps protect everybody.
I hear you. We have gone with the situational approach to
Yeah.
that. But are there any towns this small?
I have again, I'm coming from corporate.
Are there any towns this small that require annual disclosures? All employees and
Regular.
officers?
And I'm saying something a little different than disclosure.
Oh,
The
sorry.
questionnaire is a little different, because I don't want to get into what you said about, full financial disclosure. If it's something that's related to, for instance, if you were a health organization, if you own more than 5% of any blah, blah, blah type of company, you disclose that. But I don't see that you need heavy-duty financial disclosures. It's more the conflict type of disclosure.
Stephen?
I think Amber has.
Well, I agree that in a small municipality, you probably do not want to have financial disclosure. I wasn't suggesting replicating the the disclosure requirement that's used in larger municipalities in Shelter Island. I was just suggesting an option for a scaled down, simplified disclosure form. But transactional disclosure, which you're calling situational disclosure, is important, as is the required disclosure in land use applications that
Right.
that is found in Article 18.
It's already done in this town.
Good. And I
Land use
certainly,
applications.
and you certainly could have town officers and employees on an annual basis sign a statement saying that they have read and understand the code, that they have read the code of ethics and understand their obligations under the code. And also
did.
understand that the Board of Ethics is available to provide them with ethics advice.
We did try that. It'd be good to try again, but telling you, like 75 or 80% of them did return the form and say, yeah, they've read it. And the other 20 or 30%, the town clerk, I think, was keeping track of this for us. Is that right, Shelby?
I think Barbara and Coco.
Okay, Bob was keeping track. We couldn't get that close to 100% of people even saying they've read the code. But let's come back to this abbreviated disclosure form idea.
I don't remember how to.
Yeah, I was just saying, as part of the audit, the auditors do send out to definitely town board members and some other officers within the town to sign off on a disclosure statement. Do you have any transactions with the town that you need to disclose? Are you aware of any others? I can't remember the whole list. There's like 5 or 6 questions, but I don't recall how widespread it is among town employees. So that is maybe something that could be dovetailed or expanded upon.
So you're saying it's part of this state audit
Not the state audit, the independent audit of the financial statements of the town.
that they require certain level of officers to disclose if they're aware of conflicts of interest?
Yeah.
We'd love to see that.
Yes, I will find it.
Thanks. We'd love to see if you have an actual,
Yeah, so I know it's like town board and various, yes. Mhm. Yeah, so I don't know how widespread it goes below the highest levels.
okay, so great. So we see this, an idea of,
I could probably bring you some questionnaires that come from corporate world. I've also served on not-for-profit boards where I have to do, as Stephen said, every year, the signing off on basically stating that affirmatively that I am in compliance with the conflict of interest, the standard of conduct of the, I have no self-dealing, blah, 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 that type of stuff.
yeah,
I know I have those around somewhere.
yeah. We just have, it's under postage and distribution in the code that says people got to read this, and even if they don't, they still assume that they're responsible for it. But I'm interested in if any other small town has abbreviated disclosure forms.
Well, the Village of Port Jefferson has a financial disclosure requirement. The Village of Southampton, which I have not represented in a few years, I think had one. Sag Harbor has a financial disclosure requirement.
Right.
For officers or for,
Well, generally, you're required to file a financial disclosure form if you are either employed in a title named in the law, on the one hand, or if not, if you are what is described as a policymaker, and the criteria for determining whether someone is or is not a policymaker are set forth in the law. Because, in government, people are often working out of title. The actual duties that they perform are not always consistent with the position that they hold. So some people can be a policymaker by virtue of the position they hold, and others might be by virtue of the duties that they actually discharge.
Right. Okay, any other preliminary thoughts on disclosure?
I just don't think we should be too heavy-handed.
What?
I don't think we should be too heavy-handed.
Yeah, I don't either. I mean, if we can't even, but I'd love to see what form the auditor has, and if there's some,
Yeah.
Is it the fraud questionnaire you're thinking about? Yeah, okay.
yeah,
And Bill interestingly was calling it conflict. You said it's
I
You prefer the phrase
I
conflict of
usually thought
interest.
in terms of conflict
of
of interest.
interest, just to think about maybe reframing how we label this thing if we choose to go ahead with it.
yeah, and especially if it's certain people, but who's got more discretionary power, you know? Building inspector or town board member, I don't know, but building inspector. Okay, that's a good thing to raise, thank you, and let's revisit it. All I had on the procedures as they stand was to get in and allow anonymous complaints again.
And I really like the idea of us eliminating the step-by-step that we said we would follow in case we don't follow with it. It's not held against us at a later date. It's a smart suggestion.
Yeah, we never wanted to
Yeah.
get our foot in the trap and
Yeah.
that's not the point.
Would it make sense to see in other towns' procedures or not?
Do you have another small town procedure, Stephen?
So many requests.
I think the procedures that I provided you to look at are the ones that I generally use in the municipalities that I represent. They're really aimed at ensuring due process when there's an enforcement action
Yeah.
by the Board of Ethics.
Okay, let's,
I didn't get those procedures.
Consent procedures?
you sent them to us, yeah, Stephen?
I don't,
I believe I did. I can send them again.
Yeah.
Okay, one thing that you brought up last time, Stephen, was procedures for hearings. And I think I did look at, in fact, that may be the document you're referring to. And
It is, yeah.
it seemed to suggest that there'd have to be a hearing on every case that we take up. And
Oh, no. No, you would do triage. You just, when a complaint comes in, it very often, it on its face clearly does not allege an ethics violation. In the town of Southampton one time, a complaint was received by the Board of Ethics saying that I went to the town recycling center and the employee who works there was rude to me. Clearly, not good on the one hand, but not an ethics violation on the other. Or code enforcement is not pursuing my neighbor who has illegal tenants. There are a million different complaints that are received by a Board of Ethics, and most of them are not in the nature of ethics complaints. So those you would very early on dismiss. It's
Right.
only, and the next level might be some informal inquiry that you make to determine whether the particular matter merits a more formal investigation. And it's only when you've reached the point of concluding that there is a need for a formal investigation that you send out a notice of a hearing.
yeah, no, this is the point that we have not done. Effectively, we do information gathering, usually by email, sometimes by interviews. Sometimes we have people in here that we interview, sometimes not, depending on what we decide is warranted. And,
And their availability.
huh?
And their availability.
Yeah,
Come in.
I think to go over to a mandatory hearings system for cases we investigated is
Well,
too much.
Yeah, I'm not suggesting that your informal investigations use that procedure. But if there comes a time, and I hope this time never comes, when you may need to make a finding that someone has violated the code of ethics and that a penalty should or will be imposed, that must be done on the basis of a formal hearing in which that person has due process rights, they have the right to be represented by counsel, There's a stenographic record kept. There are written charges preferred against the
Had that
individual.
situation.
Okay,
But we may-
Lord, you had a comment?
No, I said we haven't run into that situation yet. We
No,
haven't
thank
gotten,
God.
things haven't got.
It's rare, and I'll tell you why it's rare. In order for that to happen, the alleged misconduct has to be serious enough to rise to the level of an ethics complaint, but not so serious that it rises to the level of a crime. Because if it's a crime, it gets referred. And so it's only that thin slice, that thin strata of conduct that rises above the frivolous, but doesn't achieve criminality.
And that, those procedures would be in code, not procedures, right? It would be
No.
hearing procedures.
Those procedures would be adopted by the board pursuant to the authority that it has under the code.
It would be in code adopted by the town board.
No,
No,
he's saying it would be in the
Just our-
procedures.
Our procedures.
Yes.
Okay, well, let's look at those,
Look at those.
because we don't want to slow everything down. If it ain't broke, don't fix it. But we do want to have a due process when needed.
You know, there's this rule that comes, I think it originates in ecclesiastical law, where you don't adopt the rules of procedure after an investigation has been commenced. You do it before.
Great.
So that you
Yeah,
can't
absolutely.
be accused of adopting rules to produce the result that you want.
Great. Great idea. And I don't mean to argue back against everything you're doing, just some context, but as long as it's somewhere in between frivolous and possible penalty or criminality. And actually, I don't think that we assess penalties. I think only the town board can do that. Upon a recommendation, we can recommend.
Right.
But yeah, everyone like that idea of getting hearing procedures in here?
Yep, but you said anything above frivolous, isn't it things above, that thing above frivolous? I
Yeah.
thought he was saying it's even above that.
Up to
It's-
criminality or
Exactly, it's that,
fine.
that, yeah.
But you don't need to put that in the procedures because you're not going to invoke the procedure unless you conclude that the situation warrants it.
And what would you call that category that you're describing, this thin sliver?
Reason to believe that an ethics violation has occurred.
But we do that. We
Right.
find ethics violations occurred and ask people to stop doing that. And they do without,
Well, if
Sure.
you find it to be sufficiently, if you do not find it to be so serious as to require action beyond don't do it again, then you don't need to invoke the procedures because the person is not being stigmatized or penalized.
right.
But if you are going to determine that someone has violated the ethics code and forward that finding to the town board, that's stigmatizing. And I would say you don't want to do that without following due process procedures.
Okay, well, let's draft that, or let's look at the draft and then let's compare how that would have affected things in real life in the complaints we've handled the last 2 years.
I
Is that
agree,
okay?
yeah, because I'm also a little confused still about this, the
Where the
levels.
thin line is.
Yes,
Yeah, so it'd be great to look at that at a future meeting, compare that to what's been the reality of the 20 or 30 opinions that we've issued,
Sure,
some of which have gone to the town board.
sure.
Cool. Any comments on all that, Bill?
I was wondering one thing during that, because how you were speaking, Doug, in your informal process, you basically give people the opportunity during the informal process to cure whatever might be out there that is unsettled, to use the word. I'll use that as the word at the moment.
Right.
And so far, everyone has chosen to cure correct? Whatever the issue would be?
Almost everyone.
Oh, no,
Okay.
not quite.
Right. Let's say almost everyone. If someone is not choosing to cure, at that point, would you start, and I'm asking this more of Stephen, you would invoke the more formal due process procedures?
Yeah, our thoughts were if it was serious and they weren't doing it, then we could board initiate an investigation that
Right,
would,
because you definitely need to due process if you're going to do anything. But if it's a matter of a simple cure, until the point where they're refusing to cure, I don't know if you need to go that way. And I guess I'm asking that as, because we would do that differently in a corporate situation, but I'm kind of asking Stephen if that's how he's
Sure.
seen it.
Sure, the board's going to have to evaluate each individual case and decide what procedures it merits. And you want to have a degree of flexibility so that you can make the judgment based upon the facts presented.
yeah, good, and.
So if they don't cure, you're gonna have to go to this secondary level.
Now I understand it, if we couch it that way,
Yeah.
that it only rises to this thing once they don't fix what.
If they don't,
told-
if there's
Then
not,
we- then this-
it's not a cure.
Then this procedure kicks in and we have to start following it.
Yeah,
But
For
you don't
instance-
want to adopt that as a rigid policy because
Right.
there may be allegations that are serious enough, if true, that you would never try to resolve it informally, that it warrants
Yeah.
a more formal, serious
like,
enforcement action.
I think we're conflating two different circumstances. One is when an employee is just coming asking for advice.
Yeah.
You know, this is my situation, do you think I need to disclose this and recuse myself? And we would say, yes, you need to recuse, say, and then they presumably would do that because otherwise they wouldn't have come to us for advice.
right,
So the other situation you're really talking about is when somebody has filed a complaint and that says this has been happening. It's not talking about something in the future, but this person has been violating the code. And in that situation is the one where I imagine we would need to have a hearing if there wasn't an agreement as to what the appropriate way to go forward was.
or perhaps if it's something that we anticipated, we would recommend a fine or removal to the town board.
Maybe, but that, yeah, I don't
haven't
see
done-
that coming up in the context of somebody asking for advice. I think that would
No.
only come up in the context of somebody filing a complaint.
Or a board initiated investigation.
Or a report, yeah.
Okay, this is something to pursue. Thanks a lot. And we need to handle a couple things in executive session. Any more public comment?
No.
Mr. Public?
No.
Okay, you promised to send a form,
I will follow up with that.
and so have you, Amber.
All right.
Thank you.
Thank you, guys.
For giving us your Valentine's
Thank
Day
you.
opportunity.
I said, we're doing that a different day now.
We have a couple matters that involve the financial and employment situations of employees. I move, we move into executive session. All in favor? Aye. Okay. Thanks a lot. Okay. Thanks for coming.
Thank you, guys. Okay. Feels like a lot of